Court rise.
Mr Taxfield.
My lords. So, my lords, I was just coming on to explain in my submission the flaw in Apple's reasoning, and as I said, their attempt, as I see it at least, to try and get round 211 by expanding the way in which arbitrariness can be seen. Now, I think in my submission this can be put, our response can be put three ways, although they obviously very closely interrelate. So the conversion always provides the benefits, whether or not the wider system takes advantage of them. And I've addressed your lordships on that. I don't propose to say anything more on that. The second point is that my learned friend's argument has insufficient regard to the nature of the invention, or the scope of the invention here, since it's not in my submission good enough just to posit that something is encompassed within the claim, and so it's problematic for a patentee. Just merely being encompassed isn't enough. In my submission, investigation is more sophisticated than that. And I'm going to develop that by parallel with the well-established law on breadth of claim insufficiency. And thirdly, it can also be viewed in terms of looking at the patentee's technical contribution. And in my submission, that will lead to the same result, and I shall explain that to you. So I've done the first point. Going to the second point. The debate here is similar to, although not the same as, one which has come up more frequently in the breadth of claim insufficiency cases. Now, there are many flavours of insufficiency, although they're all linked by certain underlying principles. But what this engages with is where a patent claims a class of things, it does not teach the skilled person how to make or do some things within that class. Now, a particular problem which may arise in such cases is how to deal with improvements to inventions or to variations in things which aren't really the subject matter or focus of the invention, but which are encompassed by the claims. So a commonly referred to example of the former, and this is from a comment by Lord Hoffman in the Kirin Amgen case. A patent claim may claim a thing in which two components are attached together by, quotes, connecting means, close quotes. So that would cover screws and nails, or glue, for example. Now, the method by which they are fixed together may not really matter for the purpose of the invention, but the problem which arises is that the claim then covers the devices incorporating the as yet uninvented new fixing means. Now, ex hypothesi, that patent cannot enable those devices. Does that mean the claim is invalid? Now, the skilled person clearly could not, without invention, have made those products. But the question is, would it be right to deny a patentee protection from all improvements of their basic invention? Or, to give you an example of the other case I posited, which arose in the recent Supreme Court decision in Regeneron. Now, that case concerned mice genetically engineered to produce a particular class of antibody. And there was argument about the fact the claim covered, but the patent did not disclose or enable, mice with particularly short or long tails. So that was really about an aspect of the claim thing which was outside of the focus of the invention, but still within the scope of the claim. The patentee again claimed those things, but did not enable them. But they don't really undermine the core of the invention that they had made. Now, the law, as it's evolved, is that neither of those issues typically leads to a claim being bad for breadth of claim insufficiency. Obviously, the facts matter in each case, but typically that's not the case. And the reason for this, in broad terms, is that the law distinguishes between factors which go to the enablement of the invention itself and factors which are ancillary thereto, even though they are encompassed by or within the claims. I'll just show you, if I made one case on this. It's the Anand Kasai case in JA2. It's JA tab 2. It's not in a sideline section, but it's at page 86 of the bundle. It's under the second insufficiency attack, advanced, which was a breadth of claim attack, as one sees from the first line of paragraph 34. And if I could ask your lordships to read 35 down to the end of 39. So, paragraph 38 is really considering what I've described by reference to the tail length and Regeneron. And as the court there comments, otherwise almost every claim would be invalid on this ground. And we say there is a parallel with the present case, because what they're really saying is you can add extra components to the system as a whole, which mean you don't take advantage of the benefits that are provided. And the second paragraph, 39, is really the one about improvement inventions in the fixing means, or that I talked to a moment ago. Now, aggrievo obviousness is not exactly the same as breadth of claim insufficiency, but it is a related area, since both are directed at ensuring the scope of the monopoly claim corresponds to the patentee's technical contribution to the art. And there are, as far as I'm aware, there's a grave danger in front of my Lord Justice Arnold in particular in this area, but there are, as far as I'm aware, there are no cases directed to this point in respect of aggrievo obviousness. But the relationship between aggrievo and breadth of claim sufficiently has often been commented upon in the cases. And in our submission, the same approach is necessary here. The court has to have regard to the nature of the invention when considering arguments of aggrievo obviousness. And we submit this highlights a flaw in my learned friend's case, because what they posit is the mere fact that something is within the claims, their case suffers from the vice of taking the fact that something is within the claims as itself being enough without thinking about its relationship with the claimed invention. However, in our submission, that takes one full circle. The fact here is that the invention always provides the benefits, and that's what matters. And it does not matter, you might be able to posit a wider system in which less self, potentially it's even said, no advantage of that benefit is taken. Now that takes me then to my third point, and it's that in my respectful submission, the same cat can be skinned by reference to technical contribution. What has the patentee really provided? Now in this case, we submit that the technical contribution of claims 1 and 9 of this patent are the method steps or the sets of components for claim 9, which convert, compare and send the converted measurements, and which thereby provide or enable the twin benefits which the judge discusses. Now, it's not surprising that the technical contribution closely follows the claims. After all, that's what the patent gives. but it does highlight that the benefits are provided across the scope of the claim, in the sense I use that term rather than my learned friend does. And it also highlights the nature of my learned friend's case, that it's the wider system which fails to take advantage of those benefits. Now, each of those submissions is obviously closely interrelated, but in my submission they do indicate that Apple's approach to the law is wrong. The other thing I would point out is, as I've said, in respect of at least simple product claims, such as the carburettor, the effect of my learned friend's case being correct would have a substantial, possibly even very substantial effect on the validity of a very large number of patents in a manner hitherto undiscovered. Now, it might be said that doesn't mean he's wrong, but it certainly ought to give your lordships pause for thought. Now, with that, can I turn to our second headline point, which is, even if Apple was right on the law, then it still fails on the facts. And what we say here can be broken down into two steps. The bulk of Apple's case, actually, when one thinks about it, really posits systems in which a lesser advantage of the benefits is taken. Not that there is none. And obviously that's never a basis for an aggrieved objection, even were they to be right on the law. Now, insofar as Apple really advances the case that there are embodiments which take none of the advantages of the benefits, then one, it's not clear what they are, but two, they are so extreme and unrealistic as in any event, in my submission, to fall within the occasional exceptions which aggrieved obviousness does permit. And it's common ground and well accepted that aggrieved obviousness, as for breadth of claim sufficiency, does allow occasional exceptions. So what that raises the question, what Apple say is that the claims do not exclude the invention being used in a system which does not take advantage of the benefits conversion provides. But one has to take a little bit care with that submission. We've already discussed that the benefits are threefold, and I've been through that. But Apple's examples, for the most part, do not, even on their case, mean that no advantage has been taken. So when they posit a message being sent on the fetch, not the satch, that message, it may not be on a non-stealing channel, but it may well still indeed take advantage of all three of those benefits. It may use the fetch in a more efficient manner by having a single message in which you can swap between, in the case of the example, UMTS and GSM reports for the particular slots, with simplified and more efficient decision making in the phone and in the network. So just saying it could go on the fetch is not anywhere near enough, not to mention we have the satch claim. Now, they also posit a system using reporting messages which only carry, say, UMTS measurements. Now, that system may not take advantage of the format substitutability, although it's still present as a result of the conversion. But even then, they will still have the advantages within the phone and within the network. Now, none of those examples in anybody's approach to the law raises an aggrieved case, since you still have some taking advantage of some of the benefits, even if not all.
So I don't understand that last point. So we're positing a system in which messages are reporting which only carry UMTS measurements. So these are unconverted values being reported.
No, sorry, they are converted values. So you're not even thinking about the claim unless you've done a conversion, and that's one of the things I'm about to come on to. They are a converted value, so in other words, they've been taken and put into the encode in a manner with those twin characteristics, but then being used in a, what you might call a less efficient way. They're not being used, the system designer has decided to use them in a message without taking advantage of the format, the commonality. But yes, they have to be converted, otherwise you're just not in the claim.
But, yeah, all right, but it's then the question of what's done with those values.
Yes. It's what's done with those values. So what they have...
Of course, if there's no conversion step at all, then you're not within the claim, as you rightly say.
Who cares, yeah. Sorry, who cares what happens if there's no conversion step? Because what it's actually going to posit is what they need to, and I think this is, sorry, the reason I'm going on is because I think it might address, I hope it might assist my lord. What they have to posit is a system in which there is a conversion in accordance with the claims, but where none of the benefits are taken. So they have to posit a system in which UMTS values are converted such as to have the format and comparability characteristics, so they can be treated as if they were GSM values in the way we've discussed, but where the system designer has decided to use a reporting message which is designed not to allow flexible allocation of the message space, even though the UMTS measurements have been included.
But at this point, I think you need to address Mr. Birkle's reliance on paragraph 174 of the judgment.
My lord, I can. This is yes, I can do that now if it helps, rather than pick it up at the end.
Well, it's kind of central to this debate, isn't it?
Yeah, let me do that. Now, the point here is my learned friend says there's an inconsistency by the judge. Now, you have to bear in mind that 174 of the judgment is the judge's consideration of the case of obviousness over the Losh prior art. Okay? And that is what the judge is addressing. And I'll come on to show you this. In fact, I address this. Can I just take my lords, if I may, to 112, I think it is, of my skeleton argument. Which is the basic point. And then I'll just expand on that, if I may, orally.
Yeah, well, I mean, there's no dispute that that paragraph is addressing the case of obviousness over Losh as is apparent on its face. But what's relied upon is the reasoning.
Yeah. Now, in respect of Losh, the Losh document contained two embodiments. In the text, they were somewhat mixed together, but the Optis' case, which the judge accepts, is it contained two embodiments. In one embodiment, the phone itself made the handover decision as between the two networks. And in that context, some kind of comparison occurred, although there was no teaching of conversion per se, and it could have been by the kind of algorithm that my Lord Justice Arnold was discussing with me before the short adjournment. But in that embodiment, because the phone was making the handover decision, then there was never any need to report any values at all. So that wasn't anywhere near the claim. Now the other embodiment, which was, like GSM and UMTS and the patent is concerned with, was a mobile-assisted network-directed handover. In other words, the mobile reports and the network decides. And therefore, of course, the phone reports measurements to the network. But in that, there was no teaching of a comparison being done in the phone. And the measurements were sent in their unconverted form. So the argument then was focused on that embodiment. And Optis' case, my client's case, was there was nothing in Losh which would cause a skilled person to think of the conversion process, the conversion process in the phone at all. It wasn't in any of the prior art, in the common general knowledge, anything like this. Now, Apple advanced a case, which was an argument based on the details of interband GSM reporting. And they said that the knowledge of interband GSM reporting would trigger the skilled person to read Losh in that embodiment and say, I know, to paraphrase the case, I can do a conversion instead. That it was rendered, conversion of the type of the claim was rendered obvious because of the knowledge of interband GSM reporting. Now the judge rejected this and said that it's only with hindsight that that comes up. But what 174 is about is what the skilled person reading LOSH considers. And I'll take my notes through it in a moment. But the real point is, when the judge says there's no reason to make a conversion in the phone, he's not saying conversion is pointless and I'm going to write something that's inconsistent with the rest of my judgment. What he's saying is LOSH gives the skilled person no reason to think of the idea of conversion. And that's why I say this is about the obviousness. It's not about whether it does anything. And if one looks at 174, the first 5 lines summarise the first embodiment I talked about. Sorry, it goes a bit further, first about 8 lines. A critical problem with Apple's obviousness case here is that the idea of making comparing values in LOSH is disclosed only as something for the purpose of making handover decisions. The skilled person would be obvious to do that in the phone if the phone was making handover decisions, but in that case there'd be no reason to send any UMTS measurement report values in a report to GSM network. So that doesn't get you within claim 1. So that's the first embodiment I addressed your lordships on. Then you get the next embodiment. On the other hand, if the skilled person was not considering handover decisions in the phone, they would be considering network-directed mobile-assisted handover. Indeed, that's the more attractive option for the skilled person. It was the common option at the time. In that case, it would be obvious, from the common general knowledge or based on loss, to send UMTS measurement information to the network. However, the reference to a comparison loss would not be understood to have any relevance to that. So he's saying there, the fact that there's a comparison in the first embodiment doesn't make, in the second embodiment, the person think of doing a comparison. There's no reason to make any conversion in the phone for the purpose of comparability. And all he's saying there is there's no reason given in LOSH to make that comparison. And therefore, he's saying that's why the obviousness case failed. And then you can see what he says next. I'm not persuaded that the fact that RX-led comparisons in both in-band and between GSM bands are made for normal reporting of handover in GSM itself, which common general knowledge will make it obvious, starting from the comparisons, etc. So there he's addressing the argument that advanced by Apple that that was the thing that would make the skilled person think, reading LOSH, of doing comparisons on the phone. So that's the context in which this sentence that my learned friend relies upon is made. And it just shows that I'm right, that what's being considered here is whether LOSH makes the skilled person think of comparability. And then the end also makes that point. It's only hindsight to see the reference to comparisons in LOSH, which would be understood in one context, and seek to turn that into a hint to make inter-app measurement comparisons in the phone for a different purpose. So my lords, this is all a summary of the arguments about LOSH, and that's all that's being discussed here, is whether, when it says there's no reason to make any conversion, LOSH gives them no reason to make a conversion, and it's only hindsight to think of a reason afterwards. So my Lord, Lord Justice Arnold, I hope that at least gives you my explanation for that, what's going on there, and I do think there's nothing in it.
Thank you.
So going back to where I was, which was just unpicking a little more my learned friend's case and the facts, what they need to do, as I think I said, is posit a system in which there is a conversion in accordance with the claims, but in which none of the benefits are taken. That's what they have to find. So what this means is they have to consider a system in which the UMTS values are converted so as to give the twin characteristics of format and comparability, so they can be treated as if they were GSM values, but in which the reporting message is designed not to allow flexible allocation of that space, even though the encoding of the UMTS measurements would enable this, and in which the phone is not programmed to take any advantage of the efficiencies that arise in the phone, and in which the network itself is not set up to take any advantages of the benefits of receiving the measurements on a common scale. They've got to posit a system that does none of those things. Otherwise, they don't get anywhere. But what exactly is this system? Apple has not described what the actual system is that they suggest is one which would not only take lesser advantage of the benefits, but none at all. Now, just looking at the third of those, the benefits in the network, that's the simplicity and the ease of the handover decisions once you've got everything in a common language. What do Apple do? Do they posit the system is designed so the network just throws the measurements away? Or that the system converts the measurements into some other format, and then back again? Or what? None of this is logical. And it's not clear what Apple's case is here. So my third point is really this. Putting all of the other arguments to one side, or even irrespective of those, if the only scenario in which no advantage is obtained whatsoever from the conversion of claims is one as yet unidentified, of such an extreme and unrealistic nature, then that's exactly my submission, the kind of thing which is permissible under the occasional exceptions which the doctrine allows. Now, my learned friend may come up with a system between now and his reply submissions. It doesn't really matter. The point is it's an extreme and unrealistic thing. Now, in my submission, that's the application as law even as accepted by Apple. It's also my submission supported by policy considerations. Where a patentee has disclosed a good and useful invention which does provide benefits, in my submission, the court should be slow to accept an argument which invalidates that patent on the assumption that a skilled person is essentially straining every muscle to create a system which breaks the invention. So I do submit that would be a substantial, unwarranted and undesirable extension in the law. Now, my lord, those are my submissions on the second head, the law. Unless you have any further submissions, I was going to turn to what I think is the last point on this issue, which is Bordeaux. Now, Bordeaux was well, I should say at the outset, I'm afraid my notes have aspects going to both Claims 1 and Claim 8. I will try and take the Claim 1 points more quickly than I was going to. They do still, however, have some relevance because it puts the judge's comments in Claim 8 in a particular context, and in particular explains why the judge, although he gave a clear indication that Claim 8 was not obvious, he didn't make a formal finding. And that's because he held that Claim 1 doesn't get off the ground. So Bordeaux was a complicated and dense document. It's not easy to read, not even in full in the bundles because of, well, procedural history, but let's not dwell on that. But it contained two relevant features. First, it was a trigger-based system. And by that I mean that reporting was triggered when a particular threshold was reached, rather than the continuous background reporting of the normal GSM system. Now, a consequence of this is that speed becomes of the essence, because what you're considering is a phone that, in fact, there were two triggers. It's a phone that's getting a very poor signal from one network and a good signal from another network. And so it's basically in a position where it needs to hand over, and it may be moving in a car or a train, it may be moving at speed, it may be a very congested area. But the consequence of this is that speed was of the essence once the report was triggered. Now, this and other characteristics of Bordeaux made, and Optis submitted this, the SACH, which my learned friend said yesterday, the S in SACH is for slow associated control channel, unsuitable because it's slow. And it made the FACH, which is the fast associated control channel, suitable. The second thing is that Bordeaux suggested in an inter-RAT and inter-UMTS and GSM scenario, the measurements should be sent to the GSM network and then passed all the way back through to the UMTS side for the UMTS network to make the handover decision. Now, this was universally considered a bad idea. I'm going to show you a bit of this. Because it would be slow, it would increase the chance of handovers failing, and it takes control from the system in which the phone is actually in communication. Optis' case at trial, which the judge accepted, was that the skilled person, having read Bordeaux with care, which is what the law requires, would simply have discarded it as a bad idea.
I still think we're going off at a tangent here. I do appreciate that you're to be forgiven, given Mr. Burkle's reference to the T-Doc yesterday. However, what concerns me is that although he sought to take some forensic advantage from it, that's not actually the basis of the appeal. And I'm concerned that we focus, as I've already indicated, on the basis of the appeal. So let's look at the way it's put in the skeleton. So if you go turn to Core Bundle tab 4 at page 38.
So can I have my lord, have you got a paragraph number, please? Great assistance.
Paragraph 109 and 110.
Thank you.
So we start at 109. This is the appeal skeleton.
Yep.
And we discussed this already. And the reliance is placed solely upon paragraph 210 of the judgment. And the argument put forward is conversion is an arbitrary feature, and therefore it follows from the judge's finding that claim 1 is invalid. We discussed that already. But then, in 110, they turn to claim 8. And the argument that's put forward here is not based upon anything in the T-Doc. What is argued is that the same reasoning catches it because use of the SACH was CGK and a known desideratum and so on. So this argument is really based upon saying, given the starting point in 210 and given what's said to be the common general knowledge about use of the SACH, then claim 8 follows as well. So that is where I would invite you to focus your submission.
My lord, and can I just make an observation about that? Because until yesterday evening, that was exactly where my submissions were focused. But unfortunately, sadly, they're not the ones I brought by mistake this morning, though. Life is ever complicated. Unfortunately, my learned friend yesterday said he bases his claim in respect of his argument in respect of claim 8 on Bordeaux making the SACH obvious. So I've now rejigged everything. I will try my best to address my lord's point, just from memory, as it were, because there are a number of concerns about 110. In fact, they are set out in my skeleton. If I just have a moment to find it. It's 102 really of my closing sorry, my appeal skeleton, because there are.
Yeah, well, I think that's what gave rise to Mr. Burkle's attempt to rely upon the T-Doc.
It did. It did. He tacitly accepted it's not pleaded and it's not part of their grounds.
Well, in terms, he disputed that. But he sought to meet it anyway.
Yeah, but it isn't a pleaded case. I can take my lords to the pleading, but it's not there. My learned friend didn't proceed to persuade it was there, so I'm not sure how showing you that it's still not there really helps in respect of claim 8. Or if that helps, I can show my lord, actually. Why don't I do that? If one looks at the core bundle, the grounds of invalidity are at, well, the grounds at 14, but what matters are the annexes to the defendant's statement of cases at tab 21, and at tab 23 we have the statement of case over. I hope this is the right one. Yes, the statement of case over Bordeaux, or 1145.
Yeah.
And everyone looks at page 209 at the bundle. So in respect of integer 1b, they have pleaded, you see at point number 1, they have pleaded the Agrivo case there, obviously.
Right.
Now, if one turns over, though, to claim 8, which is at page 211, they plead a case which was argued on the document itself, but there's no Agrivo pleading in respect of that.
Sorry, I don't begin to understand that. Claim 8 is a dependent claim on Claim 1. Therefore, we read Claim 8 as saying that it's got all the steps that are in Claim 1, including the converting step, and it's got the additional feature that the control channel comprises as such. They say that Claim 1 falls because the converting step is arbitrary and what's left is obvious, and they then say that as regards the additional feature in Claim 8, then that's there in Bordeaux.
Yeah, indeed. So, my lord, I wasn't submitting, and I apologise if that's the impression you got, that in respect of Claim 8, they can't rely upon the arbitrariness of Claim 1b.
Yes, I'm sorry, but also one needs to take into account what's under the italic, where in addition to relying on Bordeaux, they say Satch and Fatch are in any event obvious alternatives, which must be a reliance on the common general knowledge.
Yes, so I'm not suggesting they can't say that that integer, or additional integer, which is so added to Claim 1, as it were, is not obvious on a conventional basis. They plainly were saying that the Satch integer, as added to Claim 1, was obvious, either looking at Bordeaux or more generally.
Yeah.
What I'm saying is the way it's put in. Okay, well, so I thought it was being suggested that the Satch was an arbitrary feature as well.
No.
No, okay.
I don't understand that to be suggested. I
my
don't
lord,
see how it could be.
Okay, my lord, sorry. Well, in which case, I apologise. We've been debating at cross purposes entirely.
Right.
Now, when one comes to look at the Satch, there was no case. Okay, in terms of the Satch, the argument on the Satch in respect of the common general knowledge took the following form. I'm sorry, I've taken these submissions out, but I can summarise them. Mr. Simmons, so Apple's expert, expressed the view that the Satch would be considered as having 50% capacity. In other words, there was space so you could put other reports within it. There was no real dispute as to how the Satch functioned, but what Mr. Thomas said, his evidence, was that the skilled person would have not viewed the Satch as having any spare capacity, because the whole purpose of the Satch was to fill it up as much as you could with GSM measurements. And there were a couple of minor exceptions with text messages and a thing called extended reporting. Now, the judge addressed this in 36 to 38. Okay, yeah, that's brilliant. We'll start. 36 to 38. In fact, can you find Thomas's?
Yeah.
Okay, and that was supported by the evidence of Mr. So the judge rejects Apple's submission there. And that was addressed by Mr. Thomas, who's in his second report in the supplemental bundle.
Sorry, why do we need to get into that? I mean,
Well,
as you rightly point out, There is no challenge to what the judge says at paragraph 38.
Yeah.
And the key point is a skilled person would know there's some capacity on the SATC to send some messages. They would also know that any use of the SATC was at the expense of some measurement reporting. So that's a finding in your favour which is unchallenged.
Yes, indeed. When the other way, though, so I was about to talk about Bordeaux again. I don't know if. Well, in terms of the CGK, that's it. It's in my favour. It's not appealed. Now, my learned friend did yesterday talk about.
But sorry, why you seem to be suggesting that's the end of the story? But why is it the end of the story? Yes, you got to that extent a finding in your favour as to the skilled person's common general knowledge. But why is that the end of the case to you, submit?
Well, the argument. Well, there's two things really, my lord, which is. There is no pleaded case of obviousness over the common general knowledge alone.
There is for this feature,
well, my
as
lord,
we've just seen.
My lord, no. There's, with respect, no. There is an allegation that adding this feature to Bordeaux is something which the common general knowledge...
Sorry, we just looked at this. Page 2111, sorry, 211. SATC and FATC are in any event obvious alternatives. And I understood you to accept a moment ago that that must mean obvious in the light of the common general knowledge.
Yes, my lord, that the point is this, and this is trite. When one is considering the obviousness of a subsidiary claim, you have to think of the obviousness of that claim in the context of the proposal as a whole. Or to put that more broadly, to say that one thing is obvious because of the common general knowledge doesn't mean it's obvious to use that feature in a particular system. Because the system itself may be one that makes it non-obvious to use that feature because that feature is not suitable.
Absolutely, but we have to start from the correct premise. We only inquire into the validity of subsidiary claims if the principal claim is invalid. So this question only arises if we get to the scenario where claim 1 is invalid because the conversion feature is arbitrary and what's left in claim 1 is obvious for the reasons stated in 210. Then we ask ourselves, is claim 8 saved because it requires the additional feature of a SATC? To which Apple's response is, no, it's not saved because a SATC is in any event an obvious alternative, as they plead here, because it's common general knowledge. That's the argument. Now, I'm not quite sure what debate over the T-dot adds to or subtracts from that argument. It seems to me it's got nothing to do with it. The question is, are they correct that that additional feature on those premises is obvious?
But my lord, I respectfully do disagree with that. And the reason I disagree is because that is just converting their case into one of obviousness over the common general knowledge.
On the subsidiary claim only?
On the subsidiary claim, but it's still an unpleaded case of obviousness over the common general knowledge.
No. We do this all the time in patent cases, Mr Chaxwood, as you well know. We invalidate claim 1 over a specific piece of prior art. There's some subsidiary claims and we say, oh, well, if there's anything in the subsidiary claims, then they fall because all that they add is common general knowledge.
But my lord, okay, so both, indeed, you're right, but there is more to it in my submission than that. Both pieces of prior art were such as to be particularly inapposite to use with the SATC. It's not that the SATC and the FATC are alternatives. And I can show you the judge positively held that the SATC was not an obvious thing to use for the Loche proposal. And he said he doubted, because he didn't fully decide, it was an obvious thing to do for the Bordeaux proposal. So my lord, you are completely right, except that this is one of those cases where to get within claim 1 on the prior art they rely upon, they have to posit something that's particularly inapposite to use with the lower claim. And in that circumstance, it's not enough to say, well, they're both known to be things you could use, because their foundation to get to claim 1 is inconsistent with their argument to get to claim 8. And that's why I do submit it's important that the judge made findings, and the court understand that the judge said the ideas, well, he said the idea in Losh is not one you would want to use on the SATch, and he said that in about 176. In 176, he says, starting from Losh, the SATch would not be the obvious channel to use. And that's because of the details of the suggestion in Losh itself. Now, he also essentially said the same. He said the same, subject to a slight caveat, in respect of Bordeaux in 202. In 202, he first of all agrees with the argument that actually the skilled person would not follow up Bordeaux at all because it contains a poor idea, a bad idea. And he said at lines 3 to 4 and 199, the skilled person would reject its central teaching and put it to one side, third and fourth line of 99. He says he wouldn't follow it up, and then says even if the skilled person started down the road of taking a different path based on aspects of this T-log, so even if they did that, the most they get to is event-driven, triggered UMTS measurement report with unconverted values. I don't believe that's really obvious over T-dot, but even if it is, it's not in claim 1. And this is even if the skilled person decided to use the SATch and not the SAT-FATch message, which I doubt was obvious, they would not see any reason to use GSM formatting for the USM measurements.
Right, well, so your answer surely is straightforward. You rely upon what's said in that sentence of 202.
Yes.
Because to put it at its lowest, that's not a finding that the SATch is obvious in that context.
Quite. Perhaps, sorry, my lord, I was probably trying to gild the lily too much by showing you the stuff that gave the basis for the judge saying that. I think it's just because the words something like thoroughly bad idea appeared in the bundles, and it seemed like a nice thing to show my lords. But there you go, you live and learn. But that's it, that's exactly it, my lord, that's exactly it. My lords, on that point, which is subject to just a final administrative thing at the end, I think those are my submissions on that issue and indeed more generally, unless there's anything specific you'd like to raise.
Thank you.
The administrative point is when I opened, I did say I'd give your lordships a couple of final references for the other judgments, as it were. So the original Unwired Planet judgment, I don't suggest that's of enormous relevance, but it is at JA 13. There are two German judgments, which are in JA 15 and 16. Just to explain the chronology here. As your lordships may be aware, the courts in Germany bifurcate issues of validity and infringement, with validity being heard by the federal courts and infringement by the local courts. We've only included the appeal judgments from the German courts, so you've got the infringement appeal to the Higher Regional Court of Düsseldorf. That's tab 15. And tab 16 is the Bundesgerichtshof decision on validity. The order of the decisions was that there was first the first instance infringement decision, then the first instance validity decision, and then the two appeals, infringement and validity. Now, the reason I mention this is just that the first instance validity decision narrowed the claims substantially on the basis, principally on the basis of a sufficiency argument that wasn't run here, and was reversed, I'll tell you in a moment. So when one is reading the infringement appeal, the court there is considering the claims as allowed by the validity courts, and the validity first instance court required importing into the claim the formula from paragraph 15. So because this formula specifically refers to RSCP, then the focus of the claim is discussing that, and there's quite a bit of the discussion in that decision which actually is just about that formula. Now, nonetheless, even though it was narrower, infringement was found. Subsequently, the Bundesgerichtshof reversed that validity decision and allowed the claims in the form asserted by Optis, which was actually in the form of Claim 3 here, the GSM claim. Now, the judgments are sidelined, but for your note, the most interesting, or the likely most interesting parts are those concerning the conversion requirement of the claims, which are found in tab 15 at page 504 in the infringement decision, and in tab 16 at pages 541 to 542 of the bundle, and 544 of the bundle as well in the validity case. Now, the basic take-home message is that in each case they adopt the same approach to conversion as the judge did here, and as we urge upon my lords. And unless anyone's going to poke me, those are my submissions.
Thank you. Thank you very much, Mr. Texfield. Mr. Nicholson.
My lord, may it please the court. My learned friend, Mr. Birss, and I intend to stay with our respective parts of the case and each address your lordship briefly. Although I opened with a general introduction to technology and the overview of the patent, subject to anything from your lordship, I don't believe that I need to trouble you with any of that again for the purpose of the reply on essentiality. So insofar as there are any points of detail in the teaching of the patent itself to pick out by way of reply, I'll leave those matters for my learned friend, Mr. Birss. So on essentiality, having heard my learned friend, Mr. Chaxfield, I only really intend to address your lordships on two main points. The first one is the complaint my learned friend made yesterday afternoon, the discussion about whether or not the comparison at priority level 4 was good enough or arbitrary, and his suggestion that my appeal depends upon it and it's not a point that's open to me. And then secondly is my learned friend's overall approach to the essentiality case. With respect to my learned friend, I say that he's failed to actually address the case which my clients are advancing, because he's failed to deal with the fact that the judge's construction is not the construction that he was arguing essentiality on at trial. So dealing with the first point of comparison at priority 4, my learned friend yesterday afternoon sought to suggest that he was confused as to precisely what I was saying in respect of the quality of the conversion at priority 4, suggesting that it either seemed to him that I was saying that it was not good enough, which was contrary to our position at trial, or that I was saying that it was arbitrary, which again he says wasn't run at first instance in this case, it was apparently run in the preceding Huawei litigation. And the simple answer is, as I think my Lord Justice Arnold commented to my learned friend at the time, that my client's case is about the lack of conversion and not about the quality of any comparison. It's also exactly as my Lord Justice Newey observed when I was discussing the priority 4 stage with your lordship almost at the end of my speech yesterday. And for your lordship's reference, certainly in the overnight transcript, that was page 59, lines 3. It may have moved slightly in the printed version. It's not the quality of the comparison point that matters to my case. It's the lack of conversion. And ultimately, the point that I am making is that on the judge's construction, despite him coining the term comparability, which is nowhere to be found in the patent, let alone the claims, what the claim requires is a conversion, not a comparison. And with that in mind, my learned friend handed up some documents overnight. One of the first of which was an extract from our closing skeleton. And in respect of that first document, I don't object to my learned friend seeking to put it into the case on the basis that I can show your lordships the page that follows it. And I wonder if I may hand...
Seems fair enough.
May I hand these documents up? Oh, yeah. There's 3 copies there. And hopefully your lordships have paragraph 62 that my learned friend was showing your lordships, and the however that runs on into the bottom of page 15. But over at 16, the point is made that in order to be good enough, it's not sufficient for the values of the two systems just to be juxtaposed by the mappings of their equations, without any rationale to bring them into alignment. What is required is a particular juxtaposition which renders them directly comparable. And then I go on to make the specific distinction between the tables that have ended up on page 3, and there's a little extract of paragraph 25, which is precisely the point I've been seeking to make to your lordships. So I'm not saying that anything different to what's said below. And it's not the quality of the comparison that matters. It's where is the conversion. And my Lord Justice Arnold very fairly asked me the pertinent question yesterday, which was also, I believe, in my Lord Justice Newey's mind, as to whether the mere fact that a comparison occurs at priority 4 necessarily implies that a conversion has taken place, because one cannot compare two things that are different. And my subsequent discussion with your lordships was not a new point. It was simply making clear that it was entirely possible to undertake a comparison with unconverted data. It just won't be as good as if you've done a conversion. And my Lord Justice Arnold put exactly the same point to my learned friend, I think this morning. And my learned friend understood the same point. My note of what was asked was, would you accept that the mere fact of comparison does not imply that there has been a conversion? That's my point, and that's where we are. Now I say, look, none of this matters to my case. The need to convert the measurements, to put them on a common scale, is what the judge held the claims to require, and not some loose idea of comparison or comparability. And we say that's very clear from the language of the claim itself and the judge's construction of it at paragraph 103. Now, that brings me to my second overriding point of reply to my learned friend's case. With respect to my learned friend, he's totally missed the point. My learned friend's point at trial was that once he got rid of offsets, and I accept for the purposes of the appeal that the offsets point was found against me and I don't seek to challenge it, my learned friend's case was that, well, the comparison at priority level 4 was enough. Now, I have taken the judge's construction. There's been consequences to my client's case as a matter of that, and my learned friend took your lordships briefly to some of the discussion of the obviousness case on Losh over conversion not succeeding because it didn't meet the judge's construction. But having taken the judge's construction as set out in paragraph 103, that's how I come round to criticise essentiality. And that's what my learned friend has got to step up to and justify to your lordships, that the judge met his own construction. And instead, I dare say, the totality of my learned friend's submissions on this point, when they weren't touching on the side of offsets, they went back to a comparison is made, and it's an okay comparison. But that isn't the test they're proceeding. And what was very, very notable in the way my learned friends structured their submissions is that they never wanted to go back to the paragraph 103. What they always kept taking your lordships back to was paragraph 93 of the judgment. And what the judge does, just to be absolutely clear about this, so that there's no misunderstanding, I'm picking up the judgment at page 85. The judge turns to the issue of construction at 84, sets out some principles, comes down to the particular issues, conversion and comparability. At 89 under conversion, he said to its first line, it's clear from the specification that conversion described has two aspects, comparability and formatting. And for the most part of what follows then up to 102, he's focusing on the issue of comparability. And the paragraph at 93 is a sort of summary in passing of those two aspects. But he specifically comes back to comparability which he identified as a subsidiary limb of his conversion, and he deals with that at 103 and 104. And my learned friends don't want to go to that. They don't want to defend the judgment on the basis that paragraphs 140 and 141 meet that construction. Instead, they continually take your lordships back to paragraph 93. And it's no good pointing out, as was common ground at trial, that some sort of comparison happens in priority 4. It's good enough for the standard, it's reasonably happy with it, because their claim isn't to taking some values and then doing a comparison in the mobile phone. Now, the only other express point that my learned friends raised in this context was the 5 decibel point, but I think probably I overreach the points that my learned friends seek to make on that in their overall approach. I'll deal with it very briefly. What my learned friends say is look at the tables as they come over from UMTS, and we can pull those up in the judgment at page 92. That's paragraph 127 of the judgment. And they say, look, when these tables come across, there's a 5 decibel difference between the, let's say, the 0th line of the table, minus 110 dB, and what comes across from UMTS, minus 115 dB. Just picking up on that, when my learned friend was looking at decibels in some of the standard documents, he was surprised that the offsets are dBs, not dBms. I don't think it matters to anything before your lordships, but just for completeness. Decibels and decibel milliwatt are on a logarithmic scale. Adding an offset on logarithmic scales is equivalent to a multiplier. When you have a shift or an offset, the units are dimensionless, so that when you effectively conduct the product, dBm is off-shifted by dB, a dimensionless quantity, to leave you with something which is dBm at the end of the day. If you multiply 2 dBms together, you get decibels per milliwatt, and the whole scheme falls apart. So there is a logical reason to the way the offsets work. None of that is in evidence I've got before your lordships, but I thought I'd take an opportunity to answer the question that your lordship answered. So, but staying in where we are with this, my learned friends make some attempt to justify the conversion by saying, well, there's the 5 dBs. But the evidence before the judge was that no attempt was made to introduce this 5 dBs, to put them on a comparable scale. It just happens to be the numbers. And if you look at the temperature table, my learned friends put before the court that I really quite like, in tab 4, tab 5, page 3, you can make exactly the same argument on the second column of this table. The moment I look at it, I see that at the top of the table...
sorry, can you give me the...
Oh, I'm sorry, my lord. It's core, tab 5, page 44, the respondent skeleton.
Thank you.
I can look at the top of the table and say, oh, look, row 0 is minus 20, but in the middle column, which was common ground, hasn't been converted, it's minus 16. Look, there's been a change of 4. Therefore, there has been a conversion. Simply looking at these raw numbers does not begin to help you to tell you that there is a change or not a change or a conversion. It's simply a matter of fact.
Well, is that comparable? Because it's not consistently a difference of 4.
No, it's not consistently a difference of 4, but the process of conversion that one has got to apply depends on what the scales look like. Sometimes it will be a constant offset, other times it will be some sort of squared function or offset function that brings the two scales themselves. you know, when one looks at Fahrenheit and centigrade, we know that to convert between those, there's an mx plus c, as I would call it, variation. There's the 9/5 element, and there's the plus 32 element. So depending on the complexity of the conversion, depends on whether or not the exercise needed to make things comparable can simply be a constant added value.
Yeah, I appreciate that, but that's looking at slightly the other way around, isn't it? I mean, as you say, you can have an offset which is not constant at all. But here we're looking at differences in numbers which are not constant and asking ourselves, well, what's the relevance of that as opposed to differences in numbers which are constant?
I understand the point that your lordship is making.
So in other words, you could say, well, where there's a constant difference, you could hypothesize that that's an offset, even if you can't assume, you can't know whether there is or is not an offset where the differences are varying.
I say the point is neutral either way. You've got a difference, and all it tells you you've got a difference. Why you have doesn't make any difference, and particularly in the present system, if you look at the RX-lev values and the UMTS RSCP values, both of them have defined their enumeration as going up by 1 decibel for every line of the table. So if you start off by 5, the next one will be off by 6, but the corresponding
difference will always be
it will always be a constant, because that's the way the tables have been put together. So I respectfully say that as much as my learned friend valiantly tried to say, well, hang on a minute, I am missing a conversion, what can I use to support the judge's reasoning? And the 5 dB attempt is the only thing he has, it's the only thing that's mentioned in his skeleton. Of course, there's no respondent's notice on it, but insofar as he does say anything, it doesn't take him anywhere. It really doesn't begin to demonstrate the fact, and there was no evidence at trial to attempt to say that once you understand the measurement results for the way RSCP works and the measurements of how RX-lev works, the right thing to do to put them onto a common scale is to offset them by 5 dBs, and that's what we see in the table. And we respectfully say that with the experts engaged, if that's what my learned friends thought they could prove, they would have done so. But they didn't put that evidence before the court at trial. The judge didn't make a decision that it was the 5 dBs that was the offset. And I object somewhat to my learned friend trying to run it at this point to suggest that it was. So, my lords, unless there's anything else on essentiality that I can assist your lordships with, I'm minded to hand over to Mr Birkill.
Thank you very much.
I'm grateful.
May it please your lordship. I'll deal with construction first, and then we'll read the points. Well, so far as construction is concerned, no purpose is going to be served by a line-by-line review of the patent description once more. I'll just pick up the key points on the description where we differ from Optis. In particular, they say conversion is conversion of both magnitude and format. We say it's conversion of magnitude. And well, the key points on the description are this. The conversion of value takes place in paragraph 15 of the text, or in box 104 of the figure. And that is why the first line of paragraph 16 refers in terms to the converted UMTS signal strength values derived from step 104. That's the first line of that page of the patent. Likewise, box 106 in the figure talks about the converted values coming in from 104. So we therefore say that use of the expression converted values in the claim is a direct reference back to those converted UMTS signal strength values in paragraph 16, top of 16, converted in terms of magnitude, but not requiring any format for any message. Instead, the step of sending the values and therefore applying any formatting to them for the purpose of fitting them into a message takes place in the text in the subsequent paragraph 16 or in the figure in box 106. And then the other key point on the description is that paragraph 16 presents two alternatives. The first one is the one depicted in the figure. It is not the claimed method, but it's one that requires the use of the standard GSM message in order to be able to fit all the values into the SATch. The second alternative does not require any particular message format. It does not mandate a format, and the judge correctly so held, for example, at paragraph 80, last sentence of the judgment. It was an option rather than a requirement. And, well, as I've said, the first alternative, and only that alternative, is the one that teaches you how to use the SATch in order to fit all the information from both sets of measurements. And that's because that alternative shares the message space between UMTS and GSM. Well, those are the points on the description. The key points from the claims, and remembering always it's the claims that define the monopoly which the patentee has chosen to support over its full width. The claims are based on the second alternative of paragraph 16. In that alternative and in the claims, the comparison is only with a threshold, which could come from anywhere and be defined as a number calculated, built in, or sent by the network. The claims, none of the claims require any comparisons of measurements between any rats. There is no inter-rat comparison required in the claim at all. And the claims do not require the standard GSM message format, or any format, or sharing messages in which values from different rats are sent in the same message. And the judge ultimately so held at judgment paragraph 194 in the context of the TDOC, and also indeed he held it at paragraph 210, which is the one I found my Agrevo case on. And the consequence of all that is that the claims aren't tethered to the mechanism in the first alternative, the one that enabled use of the SATch and provided the benefits on which the judge was relying in the specific context of GSM and UMTS. My lord, and the cost format is only discussed as a preferred feature, and we've identified the three references in the description to format in our skeleton at paragraph 48 and pointed out that they're all preferences. One can't rely on the references to format there as a proper approach to claim construction, and all the more so given that actually the claims are based on the other embodiment. Well, with that background, one can move on to Agrevo and briefly the law. Well, it is common ground, I believe, that the correct approach to the law is in judgment paragraph 207. And if one needed fuller support, it's in generics and Yada, and I showed your lordships the passages in opening 49, paragraph 49 in particular is a 6-point or so summary of the key points. And what the law also establishes is that if you want to rely on advantages to support obviousness and overcome a finding of arbitrariness, that must apply across the whole scope of the claim. it's not enough to say that some embodiments have the advantages, for example, here of comparability and substitutability. That's what I put as the curate's egg point, that parts of it are excellent is no answer if other parts of the egg are bad. My friend referred to three other authorities that I can just deal with very briefly. Kirin, he referred to Kirin, he referred to Regeneron, and he referred to Anand Kasai. And he pointed out that different considerations may apply in relation to features going to the invention itself and features which are ancillary to the invention claimed. And well, I don't need to disagree with that. There are obvious difficulties in applying it in practice, but not here, because conversion is at the heart of this claim. Conversion is at the heart of my friend's case. It is a feature going to the invention itself. It is clearly not ancillary on any basis to what the invention provides. And for that reason, we respectfully suggest that reference to those authorities takes the debate no further forward. My Lord, our case, we say in terms, in the grounds of appeal, that the judge erred because he misconstrued the claims and he overlooked their full width. And on that basis, he considered advantages of the claims that only applied to a limited subset rather than across their width. And as to that, Optis's argument doesn't confront the fact that there are perfectly reasonable embodiments within the claims that carry out no inter-rat comparisons or have no need of a conversion of value. And well, just to exemplify, appreciating it's a matter for debate, but the standards in issue themselves, if Mr. Nicholson is correct, then the standards in issue don't need any conversion but work perfectly well.
That's because they're not within the claim.
Well, that's either because they're not within the claim or
On his argument.
Exactly, but it really supports what the judge held at paragraph 174 in relation to Losh, that there is no reason at all to make a conversion if you're using mobile-assisted network-directed handover. And my friend tried to park the judge's decision as being just based on Losh. The reality is that the judge was finding there that there was no reason at all to make a conversion in a network-directed handover, whether as taught by Losh or otherwise. So, my Lord, we say that there are perfectly reasonable embodiments within the claims, subject to the point about conversion, that carry out no inter-rat comparisons, have no need of a conversion, and for that reason, the requirement in the claim for conversion is an arbitrary one, because it confers no benefit across those embodiments within the claims, other than having conversion. Or likewise, in relation to formatting, if I'm wrong about formatting not being in the claim at all, then I say there are reasonable embodiments within the claim that use separate messages to report values from different systems, and therefore have no need for a converted shared format, or for substitutability. And my friend tried to suggest that there was some benefit in the network if one sent them all in the same language. In fact, the judge expressly considered that. We looked at it yesterday. He ridiculed the suggestion that it would help the base station if it was presented with pre-converted values. He said it was, I think, fanciful. That's 201. The idea that the phone would convert UMTS into GSM format simply to save the base station some effort is fanciful. We respectfully agree. There's no benefit at all. Certainly no measurable benefit. It's not something that my friend can rely on the basis of that finding. So, well, we respectfully suggest that the judge, because the judge misconstrued the claims, he erred in his paragraph, I think 93 and 157, in saying that the claims provided those two benefits of comparability and substitutability. In fact, the conversion adds nothing. You can simply send unconverted values, and the base station derives no benefit from that either. Well, just to touch on one argument by Optis about carburettors.
Sorry, you say you can send unconverted values, but what's the point of that submission, given the claim does require conversion?
It does, but I say that the requirement for the conversion is arbitrary because it adds no benefit. Because there is no
Yeah,
need.
but that's the point, isn't it? Is the focus of your argument is to say the requirement of conversion, you say, adds no benefit.
Yes.
But the fact you can send unconverted values is neither here nor there on that argument.
That's probably right. I mean, I'm looking at the other side of the coin. But the key point is that it confers no benefit.
Yeah.
It confers no benefit in the mobile because there's no requirement to do any comparison. And it confers no benefit in the base station because that suggestion is rejected as fanciful. So no technical contribution, and therefore arbitrary. Well, my friend had an argument about a carburettor. But his argument, so far as I could understand it, hypothesised a case of a valid patent in which the inventiveness arose in part from claim features which created high performance. So he's hypothesising a valid claim and then saying that once you've got a valid claim, then you may fall within it even though you use it less beneficially than otherwise. This is a completely different case. We're not hypothesising a valid patent. We're in fact considering the question of whether it is valid or not. So now moving on to the judge's finding of fact at 210. As is clear, that finding is unchallenged. It is a finding of fact. It provides a starting point for obviousness, and we say of all claims. Now, I may have started a hair running yesterday by suggesting that the judge might have been thinking about the TDOC 1145, also known as Bordeaux. I suggested that because his biogen analysis of it, given at that level of generality, supported it. Well, I don't know. We don't know what the judge had in mind in making his finding of fact in 210, because he doesn't expressly say so.
Mr Chaxfield has told us it was common ground, so it doesn't matter.
No, exactly.
I mean, that may have been the simple basis. The judge probably didn't inquire further, given that he appreciated it was common ground.
He didn't need to, because, I mean, he found elsewhere that the idea of a threshold was obvious because it cut down the number of values you had to send. If you weed out the weak signals, you'll have less to send. And that's the beginning and the end of the argument on threshold. And then everything else in 210 is, frankly, just back to measurement reporting, as is traditionally done. But, well, we do say that his finding at 210 then supports our case on all claims. And the reason
that's where Mr Chaxfield takes his...
That is where he takes his stand. But the judge says in 210, in terms, that the claim also covers a report on any control channel and doesn't require the use of any particular report. That process, couched at that level of generality, will be obvious to the skilled person at the priority date. Sorry, I'm reading from
yes.
The last 3 lines from the bottom. The claim covers a report on any control channel and doesn't require. Well, the judge didn't differentiate.
Of course it does, because because we know that no particular controlled channel is a feature of the claim.
Yes.
But that doesn't ipso facto answer the question of whether the additional feature of Claim 8, namely use of the SACH in particular, is obvious from that starting point.
And my answer is that the SACH and the FACH were the two well-established control channels. Each was common general knowledge, and equally obvious, the SACH had its known advantages if you could find a way to use it. And at the level of generality being addressed by the judge at this stage, each was obvious. And one perhaps needs to think about Claim 8, which really just says, use the SACH if you can. And oddly, Optis have relied on the difficulty of implementing sending a message on a SACH. That's the premise on which the whole patent is written. While overlooking the fact that the only teaching in the patent of how to do it is in the first alternative, which they haven't claimed. So, I mean, across the level of generality of the claim, the use of the SACH is obvious in the sense that it's something that the skilled person would wish to consider. And at that level of generality, Claim 8 fails for precisely the same reasons as the judge set out at paragraph 210.
What do you say about the comments about the SACH in the context of Losh and the TDOC?
Well, what I say is that actually what the judge was addressing was a rather different question of enablement, that you wouldn't see how to do it. The judge picks up at one, for example, at 196, that the document does contemplate the SACH but prefers the FACH. And really he rejects it because it's difficult to work out how to do it, not whether it's an obvious alternative to consider, because the TDOC clearly considers it. That's what he says at 196. There may be different reasons in that context to take it at a different route. But we're not now considering the specific context of the TDOC. We're considering the scope of the claim across its entire width. And Claim 8 says use the SACH if you can. It may be hard to do, but it's certainly something that the skilled person would consider doing. And it is, as I say, odd for Optis to rely on findings in relation of that kind, while simultaneously trying to preserve a patent in which the only actual enablement of SACH is in the first alternative, which required GSM, UMTS, convert to make them comparable, pick the six best, and then shoehorn them all onto the known message. Or do we say that the SACH was obvious in principle at the right level of generality? And that's enough. And well, indeed, when the judge went on to consider particular channels, he held at 212. The fact that Claim 1 is not limited to particular measurement reports doesn't mean there's any further Agrevo or Vistas case. He didn't there regard Agrevo case as dependent on a particular choice of control channel. He's simply saying SACH-FACH. In either case, you get the benefits that I've identified, but the ones that he'd identified by misconstruing the claim. And well, finally, just to stress, of course, that Optis have served no respondent's notice on these paragraphs. If they sought to challenge them, they should have served a respondent's notice. And the onus is on them to challenge the finding at 210. Or we would respectfully say, to plead that even if correct in relation to Claim 1, that they had a further argument on Claim 8 that saved the patent. And, my lord, they've done neither. Or our case in the skeleton argument I think it's 110 of our skeleton argument, we respectfully submit, is entirely on point in every respect that we set out there. I don't think I can improve on it, having now given your lordship the background behind which it was written. Or it was common general knowledge. We so pleaded. We pleaded lack of technical contribution from the outset in the grounds of invalidity as well. And the grounds of appeal certainly raise all claims are invalid for the same point. That's again paragraph 7 of the grounds of appeal. So no separate respondent's notice was served saying that claim 8 should survive even if claim 1 didn't. But we respectfully submit.
Well, they don't need a respondent's notice purely for that.
Well,
because you have to invalidate each claim.
Lord, yes.
So they don't have to serve a respondent's notice to defend their position on claim 8, even if you win on claim 1, unless they're going to put forward some reason that doesn't appear from the judgment.
Well, whether it's a procedural point or not is neither here nor there. I say on the argument, as we've put, claim 1. If claim 1 is bad, claim 8, which simply picks one of the two common general knowledge alternatives, as described by the judge at 36, 39, and elsewhere, can't provide a technical contribution. It adds nothing. It's simply a selection between two known alternative control channels, each of which was well established. And it was the SATCH, indeed, that was the one established for measurement reporting. Prima facie is the first thing to look at. So well, we say that claim 1 and claim 8 stand and fall together, and we say they fall together. Well, I think, unless I can help your lordships further, those are our submissions.
No, thank you.
My lord, I know tennis is terribly unattractive, but could I just make one point from each of my learned friends? One, because I think it's a non-point.
Just before you do, what struck me that you were potentially entitled to comment on was the admission of the additional document. Is there anything to say about the additional document?
I thought I'm on a rather thin ground there, so no.
Fine.
I say it's actually, as I said on my feet, it's dealing with, I split that argument into two, and the other pages deal with the second point. But now, obviously, you can get it.
So now you wish to be allowed to make two further points.
I do, if I could, and I can promise that neither's about decibel, milliwatt, if that helps.
Identify the points in turn, and I'll check that we're happy to hear from you on them.
The first one relates to my learned friend. My learned friend, Mr. Nicholson, threw down a gauntlet saying I didn't really address 103. All I was going to say is actually I completely accept what the judge said in 103 as a description of the comparability aspect of conversion as a whole. We accept all that, so we don't think there's a dispute there. The dispute is just that we say the standard does exactly what the end of that paragraph says. And I would add there, and allowed my forensic flourish, is so held by the judge. So that's just to say that the dispute there is not quite the one my learned friend said. And the other one was my learned friend, Mr. Burkle, pointed to a sentence in 201 of the judgment, which he said that there was something that he said, the sentence is the idea the phone would convert the UMTS value in the GSM format simply to say the BSS some kind of effort is fanciful. I haven't addressed you on that. Maybe he mentioned it before and I didn't pick it up, maybe he didn't. All I was going to say is this is yet another sentence picked out of a paragraph considering what's obvious to do in the prior art, as is made absolutely apparent by the next sentence. The judge is here talking about motivations put forward by my learned friend at trial to try and justify a finding of obviousness starting here from TDoc 1145 and rejecting that. He's not talking about the technical contributions, which he makes very clear findings on, and obviously I've referred you to 157 and 82 and the findings and the evidence underlying that. So those are my 2 points, my lord.
And I think that being so, Mr. Nicholson, Mr. Burkle, you're entitled to the last word. Should you wish to say anything else?
No.
Good. In which case, we'll obviously reserve our judgments. As you will well know, they will be provided in draft for you to point out typographical and similar points, but not to re-argue the case. I think, in accordance with current thinking, the judgment will be handed down electronically. But even were that not to be the case, then obviously there'd be no need for anyone to attend. We would be grateful if you would attempt to agree a consequential order in advance of the hand down. If there are any points of difference, can they please be addressed in short written submissions, and we would expect to deal with those in writing. But subject to that, we'll reserve our judgments, and thank you all very much for your very interesting submissions.